Law Firm 3 represents the voice of the general public, and we have decided to tackle the Herculean task of subverting the stronghold that confidentiality clauses have given to the powerful as a tool to control information by limiting access to the general public, often to our own detriment. Our thesis is confidentiality clauses should be limited in settlement agreements and prohibited in circumstances where the public stands to benefit from disclosure. Our rationale for this thesis is twofold. Firstly, there is prevalence. Numerous breaches and cases in many areas, including sexual harassment, employment, and medical malpractice, have been topical in recent times. And secondly, there is impact. If these issues were known before, the public impact would have been lessened in terms of health, safety, security, environment, economics, etc. Impact of confidentiality on the business and legal environment. Confidentiality clauses fosters corruption by allowing perpetrators to get away with crimes by using their checkbooks. Confidential cases, by their very nature, do not further the improvement of legal jurisprudence because a lot of the cases never make it to the courts. It slows down the process at which advances can be made regarding legislation surrounding the issues that were settled privately. There's also a reduction of public trust because information that should have been shared with the public is contained. We also see where confidentiality clauses circumvent justice by settling outside of the court. Our research examined issues such as nature of settlement agreements with confidentiality clauses, legal and ethical perspectives of confidentiality agreements, impact of confidentiality clauses on public interest, benefits and disadvantages to the public of confidentiality agreements, and finally, alternatives to confidentiality clauses/agreements. Now, what are confidentiality agreements? Confidentiality agreements are contracts made between two or more parties that outlines confidential material, knowledge, or information on a subject matter that the parties promise will not be divulged and so will be maintained in secrecy. Our law firm has analyzed the legal and ethical considerations of confidentiality agreements. From the legal perspective, confidentiality agreements seek to offer protection, eliminate risks, and where possible, prevent a floodgate effect of persons seeking compensation. There's also the ethical perspective where, whilst the legal requirements are satisfied, ethical considerations fosters fairness and protects the public. Finally, inference of guilt or innocence in confidentiality agreements does not necessarily equate to guilt, but can mask wrongdoing. While there are benefits to confidentiality agreements, such as need for privacy, protection of trade secrets, and damage to reputation, we see where the deleterious effects they can have outweigh these benefits. They have negative effects such as economic impact, prolongation of exposure to risk, propagation of corrupt practices. They discourage personal reform, and there's also an issue of mental and psychological impact. In concluding, law firm 3 opines that disclosure is more economically beneficial to the public than confidentiality. They increase tax collection, they reduce corruption, they also protect public health, security, and environment demands transparency. They remove unsafe products for consumer consumption, and they limit environmental breaches. Ethical issues must influence confidentiality agreements. Efforts should be made to close the door for unethical practices by the drafters of the agreement. Disclosure promotes public confidence in that the absence of a confidentiality shield will obligate manufacturers to produce premium quality goods, which in turn will boost consumers' confidence. Additionally, disclosure reduces the risk and propagation of corrupt practices. Disclosures also promote public trust in the legal systems and good corporate governance. By building on the existing supportive environments, such as better legislation for protecting whistleblowers and promoting whistleblowing, and finally, by also improving legal records and aiding legislative improvement. This was just an overview to whet your appetite and expose you to the perennial issue that has not been given enough attention. We hope that our detailed research on this matter will start a conversation that will ultimately prove impactful by passing legislation to limit the use of confidentiality clauses in settlement agreements and prohibiting them in situations where the public stands to benefit from full disclosure. We are Law Firm 3, and we thank you for your time.